While strict rules of evidence don't necessarily apply, good common sense should. What's important here is that the evidence be material and relevant. One way or another, the information about the relationship between Speed and Faberman has to come out. Arguing over how it comes out isn't really useful. I think we should allow this style of questioning to continue unless the attorney is feeding lines to the witness.
Overruled for now. But bear in mind, everybody bear in mind, that leading a witness to save time on matters that are not sensitive is okay, but let's have the witness testify, not counsel, as the things that really count.
So, Ms. Graves, isn't it true that the reason you wanted my client out of the partnership was because of a personal matter, a falling out?
What are you implying?
I think I've made myself clear. Isn't it true that there was more than a professional relationship here? You know what I mean.
That's an outright lie. I don't have to take that from you.
Well, people can get mad in an arbitration and tempers flare. They are adversaries. But the arbitrator has got to maintain control and ensure that there is decorum. You really shouldn't have any trouble doing that. Just tell the parties forcefully that their behavior is not helping them at all, and they'll understand. They understand it does not serve their interests to offend the arbitrator. And then when the sermon is over, you probably ought to declare a short recess. Okay, time out. Now, we all appreciate that everybody really cares about the case, but losing your temper or shouting is not going to help you, and it's not going to help your client, and we all know that. So let's cool off, cool down, take 5, and we'll come back.
So even if we accept the firm's view of the contract, which we don't, that the 30-day period means 30 business days, they were still 1 day late, and the penalty clause applies. Just look at your calendars and start counting with February 12.
Untrue. Take out the calendar and mark off the days. According to my calculations, we were right on time.
Not so fast. The year in question was a presidential election year. It was also a leap year. I ask that the panel take judicial notice of the fact that election years coincide with the leap years. There was an extra day during the period in question.
Judicial notice is an effective method of avoiding prolonged testimony on matters of common knowledge. For example, Independence Day is July 4th and a national holiday. An arbitrator would not require a party to produce a federal statute creating that holiday.
Fair enough. We take judicial notice that leap years are every 4 years and they coincide with election years.
Members of the panel, we move for a dismissal of the claimant's case at this time. They failed completely to prove misconduct on the part of our client in any way. We would like to proceed with our counterclaim at this time.
Mr. Chairman, this is not a court of law. There's no motion practice here. It's the panel's responsibility to decide this case on all the evidence before it.
Technical elements of trial practice don't apply in arbitration, but the parties must be able to prove their case. Although some elements of claimant's case seem a little shaky, we should go forward. Only if the arbitrators are absolutely certain that the claimant has not made its case and that forcing the respondent to put on its case would be a waste of time should a motion to dismiss be granted. But be careful. Motions to dismiss should be handled with extreme care. Arbitrators should grant such a motion only in rare instances.
We'll take your motion under submission and rule on it at the end of the case, and in the meantime, let's proceed with your counterclaim.
And so despite counsel for claimants' objections to the